Hello everyone, we are doing chapter number 8, Confronting Marginalization. Bill filed in 2003. Before it, we have done regarding the manual scavenging. And in this video, we will also study about this role of government and Supreme Court for the manual scavengers. So here is in 1993, the government passed the Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act. This law prohibits the employment of manual scavengers as well as the construction of dry latrines. So in 2003, the Safai Karamchari Andolan and 13 other organizations and individuals, including 7 scavengers, filed a PIL. PIL means Public Interest Litigation in the Supreme Court. The petitioners complained that the manual scavenging still existed and it continued in government undertakings like the railway. So that is also seen that after making this act in 1993, that is prohibit the employment of manual scavenger, but still that is existed in the government undertakings. So this petitioner complained against this manual scavenging because this work is also done by the government. So in the railway, they have seen that manual scavengers are also doing the work. The petitioners sought enforcement of their fundamental rights. The court observed that the number of manual scavengers in India had increased since the 1993 law. So after making this law, the manual scavengers increasing. So it directed every department and ministry of the union government and state government to verify the fact within 6 months. If manual scavenging was found to exist, then the government department has to actively take up a time-bound program for their liberation and rehabilitation. So that means within this time-bound program, government have to release these manual scavengers from their menial work, and then rehabilitate means they have to provide the other work so then they can get the livelihood for their living. So this Prohibition of Employment of Manual Scavengers and their Rehabilitation Act 2013 that is passed in the Lok Sabha India, that is widely spread and accepted except Jammu Kashmir, and the act intends to eliminate insanitary latrines. So that means construction of this dry latrines that is prohibited, and this menial work should not be done by the human beings because it is against the human dignity. Prohibition, what is prohibit in that? Employment as manual scavenger. So people cannot be give the work as employment as manual scavengers. Hazards, manuals, cleaning of sewer and septic tanks. So this manual cleaning of sewer and septic tanks, that is not done by the human beings because it is create the problem for the humans. Survey of manual scavengers and their rehabilitation. So there is necessary to survey regarding this manual scavengers should not be exist in the society, and these people must be provide the work for their living. Adivasi Demand and 1989 Act. So the Adivasi activists also refer to the 1989 Act to defend their right to occupy land that was traditionally theirs. Adivasis are often unwilling to move from their land and are forcibly displaced. Activists have demanded that those who have forcibly encroached upon tribal lands should be punished under this law. So they have also pointed to the fact that this act merely confirms what is already promised to tribal people in the constitution, that land belonging to tribal people cannot be sold to or bought by non-tribal people. In case where this has happened, the constitution guarantees the right of tribal people of repossess their land. So here is C.K. Janu. C.K. Janu is an Adivasi activist, has also pointed out that one of the violators of the constitutional right guaranteed to the tribal people are governments in the various states of India. It is government which allows non-tribal encroachers to exploit tribal land and to forcibly evict tribal people from their traditional forest in the process of declaring forest as reserved or as sanctuaries. She has also noted that in case where tribals have already been evicted, they must be compensated. So if that condition, if any person which are not tribal cannot sold and bought the tribal land, and if that is happened, then constitutional guarantees the right to the tribal people, they have got their land again. Then if government make some plans and policies, they have to take care of these people and must be compensated, must be rehabilitated. Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. This act is made for the that people, those from the centuries, their generations are living in the forest. So undo the historical injustice meted out to the forest dwelling population in not recognizing their right to land and resources. So that type of injustice which is earlier has done with them should not be continued, and that is recognizing their right to land and resources, recognize their right to homestead, cultivable and grazing land, and to non-timber forest produce. So that is considered that this forest is as their home, and they can also cultivate that, they can use as a grazing land, and they can also collect the forest produce. Rights of forest dwellers includes conservation of forest and biodiversity. So these rights are given to them that these forest dwellers, these are supposed to these they are the conservation of the forest, that means they conserve the forest and biodiversity. Thank you and have a nice day.